Bonjour, je suis Boris Prou, je serai le modérateur de cette conférence de presse. I'm Boris Prou, reporter for Le Devoir, and I'll be moderating this press conference. If you follow us on Zoom, you can use the raise hand function at any moment during this press conference, and after the questions here in the room, I'll hand you the mic. Si vous êtes sur Zoom, vous pouvez utiliser la fonction lever la main et je vais vous donner la parole après les questions dans la salle. So this morning it's a press conference from the Canadian Civil Liberties Association, CCLA. We'll be speaking today Cara Zwibel, the director, and Alain Bartleman, le conseiller spécial aux affaires autochtones de l'Association canadienne des libertés civiles. So we will have brief remarks and then we'll go on questions first from the room and then on Zoom. On that, Cara.
Thank you. Good morning. My name is Cara Zwibel and I am a lawyer and program director at the Canadian Civil Liberties Association. I am one of the lawyers that will be representing the CCLA before the Public Order Emergency Commission. With me is my colleague Alain Bartleman, who is CCLA's Special Advisor on Indigenous issues, and I'm going to pass it over to him to introduce himself and do a land acknowledgement.
Thank you, Karen. Bonjour à toutes et à tous, je m'appelle Alain Bartleman, je suis conseiller spécial pour l'Association canadienne des libertés civiles. Nous allons maintenant procéder au reconnaissement. Nous reconnaissons aujourd'hui que nous sommes situés à Ottawa sur le territoire non cédé à titre autochtone des communautés algonquines, dont la présence ici remonte à des temps immémoriaux. Nous reconnaissons que les Algonquins sont les gardiens coutumiers du bassin versant de la rivière des Outaouais et de ses affluents. Nous honorons leur longue histoire sur le territoire et leur longue histoire d'accueil pour de nombreuses nations sur ce magnifique territoire, et nous soutenons et élevons la voix et les valeurs de nos hôtes. We acknowledge that we are located in Ottawa on unceded Aboriginal tidal land of the Algonquin Nation, whose presence here goes back to time immemorial. We recognize the Algonquins as the customary keepers of the Ottawa Valley Rivershed, and we honor their long history of welcoming many nations to this area.
Thank you. Tomorrow, the public hearings of the Public Order Emergency Commission begin. The Commission will be scrutinizing the events leading up to, including and following the federal government's decision to declare a public order emergency in February of this year. I want to be clear about the CCLA's position. The protests needed to be addressed, but the government also had an obligation to comply with the law and use emergency powers as a truly last resort. That was not the case, and it is our opinion that their actions were unlawful and unconstitutional. We are going into the Commission with an open mind, but in our view, the government has yet to prove that the legal threshold to invoke the Act was met, and the burden is on them, not the other way around. This is what we will be focusing on at the Commission: the federal government's decision to invoke the Act and the constitutionality of the emergency orders that it put in place. As a participant in the inquiry with full standing, we will vigorously test the government's evidence and demand that the government is held to account for its actions. We believe that the inquiry must address several important questions, including, first and foremost, was the legal threshold for invoking the Act met? Were there genuine concerns about threats to national security, or was the government largely concerned about the economic impacts of the blockades? What evidence supported the government's view that there was a threat to security or a serious threat to the lives, health, or safety of Canadians? Why, according to the government, were existing laws inadequate to address the emergency? What alternatives did the government consider? Could legislation passed on an expedited basis have avoided the invocation of the Act? Why were the emergency orders drafted so broadly? When the protests were localized, why was application to the entire country considered necessary? How did the protests and blockades impact the rights and freedoms of people in Canada? And perhaps more significantly, how did the emergency orders that were put in place impact the rights and freedoms of people in Canada. When the Emergencies Act was first proposed as a bill, the Canadian Civil Liberties Association advocated for meaningful oversight and accountability mechanisms to ensure that the gross violations of civil liberties that had taken place under the War Measures Act would not be repeated. The Commission of Inquiry is an important accountability mechanism, and the CCLA is looking forward to helping to ensure that it is a meaningful one. The inquiry will also provide the broader Canadian public with the opportunity to gain a greater understanding of the events that took place and come to their own conclusions about some of the issues at play. My colleague Alain will give our statement in French, and then we'll be happy to take your questions.
Cara. Donc, je vais donner un bref aperçu du processus dans lequel nous sommes engagés, la position de la CLC, puis noter les questions auxquelles la Commission doit, selon nous, répondre. Demain, les audiences publiques de la Commission d'urgence d'ordre public commenceront. La Commission, qui est dirigée par l'honorable Paul Rouleau, scrutera les événements qui ont procédé, les événements qui comprenaient et les événements qui ont suivi la décision du gouvernement fédéral de déclarer un état d'urgence à l'ordre public le 14 février de cette année. Ce processus terminera par un rapport final qui sera publié en février 2023. Comme Maître Zwibel a indiqué, la question n'est pas à savoir si les manifestations qui ont eu lieu à Ottawa, en Alberta, à Coutts, au mois de février, janvier-février, auraient dû être réglées. Nous savons qu'il fallait nous remettre dans un état d'ordre. Cependant, le Canada est un pays de loi. La loi sur les mesures d'urgence, lorsqu'elle est dûment invoquée, accorde un pouvoir extraordinaire à la branche exécutive du gouvernement fédéral. La loi visait à régler les situations de guerre, des invasions et d'autres urgences nationales qui sont si exigeantes et menaçantes qui ne peuvent pas être traitées en vertu des lois existantes ou par moyen typique de nos processus démocratiques. Le recours légal à ces pouvoirs exige que l'exécutif ait une base raisonnable pour croire qu'il existe une menace à la sécurité du Canada et que cette menace est suffisamment grave pour constituer une urgence nationale. Cela nécessite de montrer, entre autres, que la vie, la santé ou la sécurité des Canadiens a été gravement mise en danger et que ni les provinces ni les lois existantes ne sont capables de faire face à ce danger. Le gouvernement avait l'obligation de se conformer à la loi et d'utiliser les pouvoirs d'urgence uniquement comme moyen de dernier recours. Malheureusement, cela ne s'est pas produit. En conséquence, les actions du gouvernement étaient illégales et inconstitutionnelles. Bien que nous nous concentrons à la Commission, la décision du gouvernement fédéral d'invoquer la loi et la constitutionnalité des ordonnances d'urgence qu'elle a mises en œuvre. En tant que participants à part entière à l'enquête publique, nous testerons vigoureusement les preuves du gouvernement et nous exigerons que le gouvernement soit tenu responsable de ses actes. Nous pensons que l'enquête doit aborder plusieurs questions importantes, notamment le seuil légal pour invoquer la loi. A-t-il été atteint? Y avait-il de véritables préoccupations concernant les menaces à la sécurité nationale ou le gouvernement était-il largement préoccupé par les impacts économiques des blocus? Quelles étaient les preuves étayant l'opinion du gouvernement selon laquelle il y avait une menace à la sécurité ou une menace sérieuse à la vie, à la santé des Canadiens? Pourquoi, selon le gouvernement, les lois existantes étaient-elles insuffisantes pour faire face à l'urgence? Et quelles alternatives le gouvernement a-t-il envisagées? Une législation adoptée de manière accélérée aurait-elle pu éviter l'invocation de cette loi? Et pourquoi est-ce que les ordonnances d'urgence ont été rédigées de manière si large? Pourquoi l'application à l'ensemble du pays a été jugée nécessaire par le gouvernement? Lorsque la loi sur les mesures d'urgence a été proposée pour la première fois sous forme de projet de loi, la CLC a préconisé des mécanismes de surveillance et de responsabilisation significatifs pour garantir que les violations flagrantes des libertés civiles qui avaient eu lieu en vertu de la loi sur les mesures de guerre ne se reproduiseraient pas. La commission d'enquête est un important mécanisme de responsabilisation et nous sommes impatientes de contribuer à en faire un mécanisme significatif. L'enquête offre également au grand public canadien l'occasion de mieux comprendre les événements qui sont déroulés et de tirer des propres conclusions sur certaines questions en jeu. Je suis heureuse de répondre à vos questions.
Thank you. Merci. Et on that, we'll go to the questions, first in the room and then on Zoom. Nous allons maintenant prendre des questions, premièrement dans la salle et ensuite sur Zoom. N'hésitez pas à utiliser la fonction lever la main à partir de maintenant. So first in the room, we have Stuart Benson from the Hill Times.
Hi there. You said that you didn't believe that the Emergencies Act was used as a measure of last resort, or that it could have been dealt with sort of expedited legislation. Are there any specific examples that you can think of that the government could have used instead? Because I think some of the problem was, even if there were existing laws, the police seemed unable or didn't have the resources to enforce those laws. So just, are there any examples you have of what they could have done?
Well, I think it's an interesting question about the resources, because I think you know, as I'm reading through the documents that have been produced and looking at some of the evidence that I think will come out over the course of the commission, it seems like the resources that were requested by the Ottawa Police Service in particular sort of finally came through right around the same time as the act was invoked. So I think there's a question there about whether you know, which had more impact. But if you think about, you know, situations where the government is in a very difficult situation, like a labor strike, for example, of you know, essential workers, there have been instances where the government has gone to Parliament and passed legislation very quickly to get those people back to work. Now, that's not something we would want to see happen on a regular basis, but I think there is a question here about why, if we did need new laws, why couldn't we pass those laws rather than use an emergency measure which places all of the control in the hands of the executive and takes it out of the control of Parliament? That's one of the questions I think we think needs to be answered.
Follow up?
Yeah. And just with the legislation part, do you think that that would have been possible considering the sort of, I guess, the atmosphere in the House of Commons at the time when you had some Conservative MPs that were, at the very least, not against or opposed to the protesters? Do you think they would have been able to have gotten that through?
I guess I would expect that, you know, sort of emergency legislation, as it were, would probably garner the same level of support that the proclamation did. So I think it probably could have passed. There was, you know, I think there was support for that. But
Mylène Crête, La Presse, question?
Oui, I'll ask my questions in English if you don't mind. I was wondering, we had some of the answers to your questions during the parliamentary committee. So why are these answers unsatisfying? For instance, they invoke the blockades in other areas of the country, in Coutts, Alberta, Emerson, Manitoba, to say that it had to apply to the whole country. So why is it not sufficient in your eyes?
so, I mean, the blockade in Coutts was dismantled before the emergency was invoked. And it's not to say that, you know, when we say that it didn't have to apply to the whole country, that doesn't necessarily mean it could only apply to one place. It could apply to more than one. But, you know, it applied to the territories where, as far as we know, there was nothing happening. You know, it applied to the Maritimes that had a couple of, I think, of early, you know, convoys, but nothing on the level that we saw in Ottawa. And, you know, I think one of the really significant things that we're concerned about was the breadth of those emergency orders and how that breadth was communicated to the public. Because I think there was, I think the government may have used the confusion that the breadth of those orders engendered to their benefit. So I think that there was a I think Canadians weren't sure, if I'm donating money, are my assets going to be freeze? That's something that Canadians were unsure about. And I don't think the government took much time to really clarify that, because I think the goal was to prevent people from, they wanted to stop people from donating. They wanted to stop people from contributing to these causes. They wanted to stop people from protesting. Even protesting that didn't interfere in the way that many of the Ottawa protests did. So I think that those are some things that we want to hear more from some of the government witnesses about.
And regarding the police resources, I recall the acting police chief saying on numerous occasions that they did need the Emergency Measures Act in order to have that many, was it 1,800 police officers, like hundreds of police officers coming to Ottawa in order to deal with the protests. So what do you think of that?
So I guess I'll need to hear more from those witnesses when they testify at the public hearings. But I think that certainly over the course of the weeks that led up to the invocation of the act, they were getting officers from all over the country. There were memorandums of understanding with other police forces so that they could come and execute their duties here in Ottawa. I don't think that there's anything that was required from the Act to make that happen.
Next up, Mary Kay Walsh, Globe and Mail.
Hi there. I have many questions, but first of all, the what you were answering first to the Hill Times about other legislation. I mean, the Emergencies Act is the legislation that's there. Why would they create legislation to duplicate it? So can you just specify more
Sure.
why that matters and what the distinction is?
Yeah, so the federal government declared a state of emergency using the Emergencies Act, and then the executive branch passes these executive orders that are the things that say you can't gather, that financial institutions have obligations to freeze assets of people who are designated individuals. Those are the things that the government could have done by way of legislation that would have benefited from parliamentary scrutiny in advance rather than after the fact.
But what is the difference between Parliament voting to invoke it and the scrutiny that comes with that versus having these new laws on an expedited manner in which they might skip over the committee process anyways? I don't understand the distinction.
Well, the distinction is that you have Parliament weighing in before the measures are in place instead of after the fact. So by the time Parliament approved the state of emergency, those orders were already in place. They were already operational. And I think also what I was mentioning before about some of the confusion around the scope of the orders, that's also something that might have been addressed had there been debate in Parliament in advance.
And then I just wanted to get your sense on the commission generally. Are you satisfied that the witnesses that are listed and the setup of the commission is actually going to get to the heart of the question as to whether the government met the threshold? Because we're not hearing from the provinces. We're not hearing from Doug Ford, for example. The accountability for policing is with the municipality and the province. And the federal government had to step in because it fell apart at those levels. So are you satisfied that we will actually get the answers you're looking for?
So I don't know yet. I think we have to see what happens during the course of the public hearings. I mean, we are hearing from municipalities that were affected. We are hearing from witnesses from Ottawa, the Ottawa Police Service, the Ottawa Police Services Board, members of council. I think there's also questions around what will be held back, and that's one of the things that I don't have a good handle on yet. I know what documents have been put forward, but I don't know what documents have been held back or the reasons for that. And those are some of the things that I think will be explored over the course of the hearing. So I think we will have questions about whether the government is being forthcoming enough, whether the evidence is going to allow the kind of transparency that we think is required. And I can say that already I mean, the timeline that the commission is working under is set out in the statute, so they are stuck with it. They are stuck with having to, put a final report before Parliament in February of 2023. That's a very short timeline, especially given the fact that the government waited almost the full 60 days that they had to actually name the commissioner. So that's 2 months that were lost that could have been used to start gathering evidence. And I think that, they have a very ambitious schedule, the commission. There's a lot of witnesses they want to hear from. There are a lot of documents to get through. There's also a whole policy phase. So I think it's still to be decided. And one of the things that, that may come out of this process are recommendations about amendments to the Act around this process in particular. Do we need more time for an inquiry? Do we need specifics in the legislation that would address whether the government can hold things back from the commission, or whether, everything needs to be provided?
David Fraser, Canadian Press.
Hi, just following up on my colleague's question there regarding transparency. How confident are you in the government's commitment to transparency? Are you concerned at all the government will try to shield evidence from being made public by having it presented in camera just to the commissioner? And can you comment on how your confidence level in the government's ability to be transparent has been impacted, if it has been impacted at all, by CCLA's ongoing judicial challenges taking place now as well? Thanks.
Yeah, so I do have concerns about the level of transparency that the federal government, has been displaying throughout this process. When we are also, we've also sought judicial review of the decision to invoke the Act, and so there's been discussions about documents and about cabinet confidentiality in that context. And it's not that we don't recognize that there's a sphere of activities that the government rightfully can protect. But one of the things that the Emergencies Act requires is an explanation that gets put before Parliament about why the Act why it was necessary to declare an emergency. For me, that document is the government's answer. And if they start to say, well, there are other things, but we can't share them, or there are other things that we're not at liberty to disclose publicly, I think that's a problem in terms of not being forthright with Parliament and not being forthcoming with the Canadian public.
Just as a follow-up, outside of what the government actions at the judicial review level, has there been anything specific to the commission process that has carried forward your concerns a little bit more, or made you think those concerns more?
I think it's probably still too soon to tell. Certainly I was anxious to get access to a documentary database long before it was made available to me. But I appreciate that the individuals that are working on the commission are also dealing with, with a huge challenge in terms of all of the material that needs to be reviewed, and also the back and forth that they're engaged with the parties that have that evidence. So I think it's a huge undertaking. But like I said, we are going into this with an open mind. We want to hear from the witnesses. I think the commission, I have every reason to believe that the commission process will be a robust one. And a lot will depend on how forthcoming the witnesses that appear are.
Thank you. I believe that's it for the questions in the room, unless you want a question, Nimin. That's it. So we'll go to Zoom. I'll remind every reporter on the line to use the raise hand function at this point. So I'll hand you the mic. First up, Alex Balingol, Toronto Star.
Hey, thank you so much. Just kind of bouncing off the questions of your confidence in the transparency. The government had said that they would hand over a lot of cabinet confidences. I think that the quote was, all documentary inputs that went into their decision would be given to the inquiry. Can you tell us about whether you feel that given what you've seen in the documentary evidence, that is something that they've actually fulfilled, and whether those inputs will be public so that the public can scrutinize all of those?
So I think at this stage, I probably can't do that, partly because I've just not managed to get through looking at everything that the government has put forward to the commission. And I think that even what I have access to at this point is probably not the full scope of what will be put forward. And I think some of it will also have to come from questioning witnesses about, we only know what's there. We don't know what's missing. So we'll have to ask some of those questions. I think also there are questions in my mind about whether what was provided to the commission is what is going to be provided to all the parties to the commission and to the public more generally. I do know that any document that is put to a witness or that is raised during the course of the public hearings should be going up on the commission's website within a day or two of that document being put forward. So I think these documents will get public, the light of they'll be put before the public, but I don't know yet whether it's sufficient.
And just on your concerns about the emergency orders and the open question, I guess, about whether they respected people's rights and freedoms. Wonder if you can just get more specific about which orders and how they may have violated the people's freedoms.
Sure. So there were two emergency orders that were put in place, and I'm not going to remember one is, I think, just sort of called the emergency regulation, and another one is the economic measures regulation. The emergency regulation restricted public gatherings, restricted, public assemblies. It did say that they were only restricted if they were likely to give rise to a breach of the peace or language similar to that. Again, the problem with that kind of language, especially given what was going on in Ottawa, is that I think people who genuinely were interested in engaging in peaceful acts of protest would have real concerns about whether they would just be lumped in with other individuals who might have been involved in illegal activities. So there's a scope sort of question about that order. The other order that deals with financial, the financial or the economic measures, basically, charged financial institutions, all financial institutions across the country, to freeze the assets of anyone that they thought were involved in breaches of the first order. So, and again, there's some vagueness in these orders and how they were communicated to the public. And I think even, and I think this evidence will come out over the course of the inquiry, I think even the financial institutions themselves weren't exactly sure what they were supposed to be doing. We know that there were names given by the RCMP to financial institutions, but in addition to those names, the order itself laid out an underlying obligation for the financial institutions to do their due diligence and take measures against anyone they believed were implicated. So that's where we got the confusion from members of the public about, are my assets going to be frozen if I made a small donation, or what's the scope of this? So I think those are things, again, that we'll learn more about over the course of the inquiry. But when it comes to how those impacted the rights of Canadians, first of all, there's privacy issues in terms of law enforcement and financial institutions sharing information. There's no due process with this, not even notice, really. There wasn't a notice requirement, so the financial institutions didn't have to advise you that your assets had been frozen. So those are, significant deviations, I guess, from the norm that exist in our democratic society, and those are things that we want to question and probe during the course of the inquiry.
Thank you. Next question, Fraser Needham from APTN.
Yeah, thank you. The fact, I guess, that this current act exists is because the War Measures Act had to be refined, right? So that this was the first test of it. With so many questions arising, as you know, that's kind of why we're here, of whether, it's not even clear that anyone that was in Ottawa, that the police here were actively trying to stop the protest before, sort of the large weekend that led up to it being stopped. So, and there was, as far as I can remember, there's no declaration that by the Ottawa mayor that needed, the federal government to step in, and there was no declaration, I don't think, by the Premier of Ontario that the federal government needs to step in as well. So are you thinking that regardless of what happens here, is that this act is going to have to be amended because of there's so many questions now around it?
I don't know if I'd say that it would have to be. I think the experience that we've had should inform, potential amendments. And like I said, I mean, this is more on the procedural level than the substantive one. But just this question of how long does an inquiry have to look at the questions that came out of declaring an emergency, and what kind of transparency measures are required from the federal government when they do declare an emergency. I think those are things that could be usefully addressed by amendment. So I would imagine that there will be recommendations coming out of the inquiry that will address possible amendments to the Act.
Yeah, and I guess just to follow up on that, are you foreseeing a lot of questions of provincial, federal, municipal jurisdiction? Because again, there's, it didn't actually happen on Parliament Hill. It happened in the city of Ottawa municipality, right? And it's sort of their area, and then the municipality is sort of a creature of the province. And this is a situation where the Parliament just stepped in. Do you think those kind of issues will come up?
I do. I mean, I think it's made more complicated by the fact that we are in a federal country, and that that municipalities are involved, and even that the way that police oversight and governance is done varies across the country from place to place a little bit. So I think there are difficult questions about how to manage something like this, where you have different jurisdictions with different authorities engaged.
Thank you. I don't see any more hands on Zoom, so if you don't run out of time, perhaps we have another question in the room, and if other reporters also want to answer.
Sure.
All right,
Thank
Marika.
you. Marika Walsh again with the Globe and Mail. I just wanted to go back to your arguments on why you believe the government's invocation of the Act was illegal. Can you specify which elements of the threshold the government has not proven? Like, where are the question marks in sort of, they have to explain the justification. So what are the missing pieces for you?
So I think one has to do with this question of a threat to national security and what that means. And this might go to broader questions about the way that threats to national security are defined under the CCLA Act, which is sort of the touchstone that the Emergencies Act relies on. But generally, we consider threats to national security to be things that would put people's lives at risk, serious acts of violence, or genuine attempts to violently overthrow the government. Those are not thresholds that we think have been met, or at least we haven't seen the evidence that demonstrates that. The other thing I think has to do with the adequacy of the existing laws. And this might be, a legal question, whether the way that the Act is framed, it talks about there not being, laws that can address it. And this goes to a question that someone else posed. Does that mean that the laws don't exist, or that they're not being applied and enforced? And how do we work through those issues? So I think there's more information that we need about the discussions that happened, particularly between the federal government and the province of Ontario, about the powers that the province had and could have used. Those are some of the sort of threshold questions.
Okay, and just going back to your question around the documents, can you be more specific around what documents you understand that you will be receiving or you have received, and where are your question marks? What documents are there question marks around that either the government has already said it's not releasing, or that it's unclear?
I don't think I can answer that at this stage. I have I have access currently to a large amount of documents. I have not been through them all. I've also, as counsel before the inquiry, given an undertaking that I will not discuss those documents. Many of those documents will be put to witnesses and made public over the course of the public hearings, but I don't know yet which ones. And I don't know. I also don't know what was requested. So when I'm looking at the database of documents, I don't know what questions were asked by the commission to get these documents, which does make it a bit difficult to assess whether it's sort of complete and answers all the questions that we'd want.
And can you clarify that? Will you guys be cross-examining all witnesses, or only some, and if so, who?
So the parties have the opportunity to ask to cross-examine witnesses. Obviously, there's a lot of witnesses to get through. There's a lot of parties involved, and the commission has asked that people try to coordinate and cooperate so that things get through in the time that we have. We will not be cross-examining all witnesses, not by any stretch. I expect we will cross-examine some, but a lot will depend on how much gets covered, because the way it will work is that commission's counsel will question the witnesses first, and it may be that that all the questions that we have get answered over the course of that process. So we'll have to see. We'll get a little bit of notice about what the scope of their questions will cover a few days in advance of each witness, and then we'll have an opportunity to decide whether we want to cross-examine.
David, other questions?
Hey, Dave Fraser again with the Canadian Press. Real quick, just you mentioned there interested in learning more about the communications between the federal and provincial government. Were you surprised, or would you have liked to see Premier Ford on the witness list?
So I have to take another look, because I know that there are some witnesses who are not appearing in person, but who there are going to be sort of statements from those witnesses that will be introduced. I don't know if Premier Ford is one of those. It may be that that's sufficient. I have to say the list of witnesses is quite long, and many of them are names without much context. So I assume there will be witnesses that we'll be hearing from at the provincial level, and we'll have to see whether those are the witnesses that have kind of the pertinent information that we need.
As the moderator, perhaps I'll just ask one question. One last, Boris Proulx, Le Devoir. If the commission finds that it is not supported by evidence, that it was not justified from at the first place, then what happens?
Well, I mean, it's done, right? What's done is done. But I think that's an important finding. I think that's an important finding for Canadians to know. I think it helps inform future governments about when this act can be used. It might affect how people feel about the government. It might affect decisions when it comes to election time. So I think those are important questions to answer. But I mean, obviously, what happened in February is over now. So there's no sort of recourse to go back. But this is an important piece of the accountability that's really mandated by the act itself.
Thank you. Merci beaucoup. That puts an end to this press conference. Merci beaucoup aux deux panélistes. Au revoir.
Thank you.